Television 4th Department. Hear ye, hear ye, hear ye. All persons having business before this court withdraw in their attendance and shall be heard.
Good morning. Please be seated. The first case on for argument today is People v. Johnson, case number 4. Mr. Bunch, can you hear us?
Yes, Your Honor.
And we can hear you loud and clear. Counsel, proceed.
Thank you. Good morning, judges. I wanted to first focus upon the search warrant in this particular matter. And opposing counsel, I think, does a pretty good job in his response brief by pointing out which officer got the information from the female at the residence, and then which officer then passed it on to another officer, who then passed it on to another officer. But that they're trying to bootstrap the information gleaned after the warrant was signed to the actual warrant, and that's in opposite to the approach at hand as set forth by People v. Roberts, 195, a 4th Department case, 195 AD 2nd 1018. It's the validity of a search warrant depends upon the sufficiency of what's found merely within the 4 corners of the document, and it's the information known only at the time by the issuing judge that's relevant, not what comes after the fact. And in this particular instance, there's merely a female and that passed on information to police. There's no telling, like a game of telephone, which police officer got that information. The affiant that appeared before Judge Case was never at the scene, never spoke to any sort of informant.
So you're suggesting that the officer that interviews the victim, in this particular case, the woman who's who's in the hospital, victim of domestic abuse, that if time is of the essence, that officer still has to stop, leave the hospital, race down to the courthouse, find the judge, and be the one to actually present before the judge. That can't be done any other way.
Well, no, in this particular instance, the female was at the scene. So the female was on site at the house, giving information to police officers, allegedly. And in that instance, there's no reason why, if this female's providing information, hey, there's guns in a safe, to a police officer, why she couldn't then go with that police officer down to Judge Case so he could ascertain her credibility and ask her probative questions and making a determination whether to issue a search warrant or otherwise.
Am I incorrect that the discussions didn't begin at the hospital, that the police were interviewing her about the domestic violence? They went in the hallway, they spoke to the sister in the hallway of the hospital. The sister said, oh, by the way, there's guns. They then went back into the hospital room and questioned the victim. Is that wrong?
No, that's accurate, but that was in the morning. The female, Miss House, then went home, was at the house with Mr. Johnson some 5, 6, 7 hours later when police came to the residence, started again speaking to Miss House. So that's when they're speaking to her. They get a key from her, evidently, to access that upstairs unit where the guns were found in the safe. So it's at that juncture where, certainly at that juncture, Mr. Johnson's under arrest at that point. There's certainly no sense of urgency then.
Do you have any authority standing for the proposition that for a search warrant here for the safe, the person who provides the information for probable cause needs to appear before the issuing judge or sign an affidavit? Is there authority on that, or can it be hearsay? The person with the information tells the police officer swears to it.
It can be hearsay. It certainly wouldn't be preferred practice. But I think the issue here is the fact that she didn't provide the information to Officer Finera. Officer Finera was the affiant that appeared before Judge Case. In fact, we don't know who she, based upon the search warrant, provided that information to at all. And I think that's what's key, is the search warrant itself simply says she provided information to police, not Officer so-and-so, who then passed the information on to Officer Finera.
So hearsay is okay, but not double hearsay.
Double hearsay could potentially be okay. We don't know if this is double hearsay, triple hearsay, 38 layers of hearsay, because police isn't a person, and I think People v. Bartholomew, 132 83rd 1279 is dispositive, because in this instance, without it being possible to tell from reading the search warrant who provided the information contained in it, and certainly Ms. House evidently provided it, but then the other chains of the individuals involved are not identified within the warrant. How could they be reliable when they're not even named? And I think that's where they fail. And in fact, to the point where then there's an addendum on the warrant, where that came from, who knows, where it says Mr. Johnson never left the house from the time of the assault, which would be impossible for anybody to know, yet alone Officer Panera. So I think there's real issues with the search warrant, and from that standpoint.
We'll take a look at that.
Okay, thank you. And then I think there's also a weight of the evidence issue. In this instance, and I cited the King case, which I think is directly on point. There's some of my client, Mr. Johnson's DNA on the gun as a secondary source. The primary source comes from a female. There was one female in the house. It's the same female that lived there. That's the same female, by way of inference, that opened, that had keys to that upstairs unit where that safe was held. So when you're talking about proof beyond a reasonable doubt, I think there's a logical inference that any DNA that could have, that my client could have transferred onto that weapon could be from a tertiary transfer. There's nothing linking him to those guns aside from secondary DNA when his domestic partner lived at the residence, and it would be apparent that it was her DNA which made up the major profile.
As far as corroborating evidence, what about Officer Timizzi's recollection that he said, you know, they shouldn't be up there, as he's in the car on the street while they're searching the house? That statement, why is that in and of itself not sufficient?
Well, only because I don't think that establishes possession. Saying whether police officers should or should not be going to a certain unit, he's not claiming ownership of that unit. He could be, it's by way of inference, he could easily just be saying, that's my girlfriend's house, don't go up. You're not allowed to go up to that second unit. It's a vague comment that doesn't speak to possession in any way, shape, or form.
Officer Redmond's testimony that at central booking he said that was his address?
Well, there's conflicting evidence to that point.
True.
And I think when there's only one person with firsthand knowledge as to where Mr. Johnson lives. That's Mr. Johnson. He testified at trial that he lived at that Garden Village apartment in Cheektowaga. Moreover, that's where he's probation to. So I think it sort of belies common sense for him to admit to a violation of his probation and put himself closer to the guns at issue. So I think there's a lot of question there. But even if we were to say that is one place where he stayed from time to time, which is more or less what he said, I still don't think you could get to proof beyond a reasonable doubt based simply upon secondary DNA.
If we go there, then we have the lease. That came out on cross-examination.
Well, I think the interesting part about that is there was no lease introduced into evidence at any point. So again, there's a lot of holes within the testimony, which I think in their totality certainly create reasonable doubt. But I would agree with you that if there was a lease that Mr. Johnson signed, putting himself as a lessee, I think it's lessee of that particular address, by all means introduce it into evidence. It never got there, and there were a lot of inconsistencies I pointed out within the bulk of the brief, which I think, again, questions some of the officers' credibility. But moreover, I think it's aligned with the King case in that even if we were to say that DNA showed at some point in time Mr. Johnson may have touched those guns, it certainly doesn't establish they're in a safe. It certainly doesn't establish that he possessed them on the day in question.
Thank you, counsel.
Thank you.
Mr. Punch?
Thank you, Your Honor. First, regarding the lease, it was defendant's own testimony that he did sign the lease to that for that apartment. Whether or not the actual lease admitted into evidence, I don't think is material. Regarding his DNA, it shows that his DNA at some point he touched the weapon. We don't have to prove that he was the only person that touched the weapon. That, in conjunction with everything else, I believe is sufficient to establish constructive possession. He stated that this was his residence. He was on the lease. He knew who was inside the house, and he at least believed that he had the ability to prevent the police from going in, especially to that room where the gun was located.
What about the argument with respect to the search warrant and the double, triple hearsay argument?
Well, Your Honor, we know that Officer Clark, Detective Clark, was at the scene personally speaking to Chantel House. Chantel House was the person who established probable cause that the weapon would be inside the house based on her personal knowledge. So both links in the Aguilar Spinelli are meant for her. For the police officer, it's an identified police officer, Detective Clark. That establishes both links for the police officer because he's presumed to be reliable. And then we know that that went directly to the detective who was the affiant for the search warrant. So I think it doesn't require speculation, and it's double hearsay, I guess, but it's both aspects are established.
Anything further, counsel?
No, Your Honor.
Thank you. Case 5, People versus Cerrone. Mr. Keene, can you hear us?
I can.
And we can hear you. Please proceed.
Good morning. May it please the court, Brad Keene or Cheryl Cerrone, the appellant. I'd like to start with our point 2. We assert that the trial court abused its discretion in barring appellant's son and 2 associates from observing the trial. I think the Williams and Dawson case relied on by the people are different in that here neither Devante nor the detective Isengard could even identify the names of 2 of the 3 men that were excluded from trial. The trial court.
Counselor,
Yes.
let's stay to that point for a moment. Isn't that because presumably they were gang members from Rochester? I mean, the detective from Canandaigua wouldn't know those individuals.
Well, Your Honor, I think that the key word that you just used is presumably. The court made no inquiry whatsoever into determining who 2 of those 3 people were. One we know was the son. The other 2, we have no idea who they are.
Well, the detective did say he thought one of them was a gun runner, didn't he? Provided guns to Mr. Delgado?
Your recollection of the record, may be better that he thought he was a gun runner, but whether that was the case or not, the court didn't ask the individual himself what relation he had to the case, what he had to do with anything in the case. And I think that the Reed case from the Court of Appeals provides some guidance as to, what kind of inquiry should be made and whether that's an abuse of discretion or not.
Mr. Keene, is there any indication here in the record as to whether any of the 3 men in question had sat in on any other parts of the trial before that or after that, after the victim was on the stand? And
Again,
would that be relevant at all?
I absolutely think it would be relevant, and that's a great point as to why an inquiry is necessary and why the record should have been more robust, I guess, before making a determination. Otherwise, we're left believing that there's a lack of discretion.
In the Ming Lee case, was there any discussion as to the identity of all the men that were outside the courtroom waiting? Because it seems that this is analogous to that case, and I didn't see any identity of those folks either. Do you remember that the Court of Appeals case, People v. Ming Lee? It's in your brief.
It is, yeah, Ming Lee is in my brief, and I'm not quite sure whether or not that specific part, I could take another look at it. I can't say for certain.
I would say this on your behalf, Mr. Keene. Ming Lee is generally on point, but the facts are better for exclusion there. In Ming Lee, as I recall, the gentlemen who were excluded had committed misconduct themselves. They're the ones who had abducted the witness themselves and beaten the witness, whereas here it was associates, friends or associates of the person who had previously shot at the witness. So it's a little different here, but the general principle of Ming Lee seems to apply is that if a witness is intimidated or distraught in the presence of somebody in the gallery, then the court has some discretion there to exclude the people who are making them distraught. That's the general principle there.
And I don't necessarily disagree with the general principle, but in this case, where the defendant indicated that he was okay at certain points and that we don't even know who those people are, I think more needed to be done on the record. It sounds like the court has a good handle on that issue, but I do want to get into the prosecutorial misconduct a little bit. I recognize we have a preservation issue there, but this case is pretty unique in cases I've read. The open mocking and ridiculing of a defendant by the prosecutor it was really unfortunate on this record. And then the prosecutor makes that reference to the George Floyd case in summation that I found to be very inappropriate and, really could have swayed a white juror to go a different way. And, I'd really encourage the court to make some kind of statement about those kind of acts by a prosecutor.
Should we make a statement about the defense counsel's reference to George Floyd in the opening statement? Was that similarly improper?
Your Honor, it was not an opening statement. It was in voir dire. And in voir dire, I think the stakes are a little bit different there. And I'm not trying to defend that necessarily. But the level of what the prosecutor said and the quotes that are in the brief that I'm sure the court is aware of, I think takes it to the next level in terms of prejudice and inappropriateness.
We'll take a look at that, Mr. Keene.
Thank you, Your Honors.
Thank you, Counsel.
Good morning, Your Honors. Caitlin Porter on behalf of the people. I will just note on page 383 of the record, the court did confirm that the men were not present before and any time before they walked in at that point during the victim's testimony. So it's very clear at the moment that they walk in, immediately the jury is excused. The court conducts additional inquiry with not only counsel but also brings in the victim back for an ex parte hearing outside of the presence of the jury, brings in Detective Visengard as well to give testimony. So I would submit that the record is filled with exactly all of the reasons why this victim could not continue in the presence of those three men.
The witness said he could, actually. At the end, he offered to testify. He said, bring him in. I don't care anymore. Bring it on, or let's play ball or something is what he said.
And I know the part that you're referring to, Justice Lindley. I think that the context of that is important there because the victim explained repeatedly that he did not feel comfortable testifying in front of these men, that the statements that he would give on the record would get back to that same gang. It was only when defense counsel stood up and the first question out of his mouth is that, well, are you aware that this is all public record anyway? That was very clear that the victim took that as a threat from defense counsel, that this was still going to get back regardless of what happened. And he seemed to take that very personally. And then the statements that he made after that point were that no one can intimidate me, let's go, essentially. But really, he shouldn't have had to do that. He should not have been put in that situation, which is what the court said. And we're looking at the nature of the charge, the behavior by the defendant in bringing these individuals in.
And this was all previewed, though, in the phone call that was recorded where the defendant said, Anthony's got friends.
Correct. She identified him by name, and that which son of hers was going to come, and that he's this intimidating figure with all of these big-time connections in this gang.
And he walked in at the very moment that the victim takes the stand.
Correct. And that was also after the defendant had been unsupervised, contrary to the court's, not ruling, but contrary to the court's directive that she remain under supervision. She did leave for a period of time, was unsupervised, and that's when the victim retook the stand during cross-examination and the three men walked in. Regarding the fact that they were not identified by name specifically, there is no case that makes that determination that a spectator or anyone in the courtroom that is going to be excluded needs to be identified by name. There just needs to be sufficient information in there as to why that person is going to be removed from the courtroom. And they are referred to repeatedly as this group of 3 men, these 3 gang members. And there was reference earlier to the Mingley case, and I checked the notes that I have from that case. It's my understanding that those men were part of the same gang that had abducted the victim in that case. That does mirror the facts that we have here, and that these men are of the same gang that the defendant had used as a threat against the victim in this case. They're all part of that Bloods offshoot, so the facts here do mirror the Mingling case in that regard.
Do you want to address the prosecutorial misconduct argument?
Yes, Justice Whalen. So I do point out in my brief that the comments that are made, aside from the summation points, but all of those are made outside the presence of the jury. I think that the transcript here speaks for itself, and that there was quite a bit of rather outlandish behavior coming from the defense table in this case. There were a number of speaking objections made in front of the presence of the jury. There was the defendant's behavior in crying and making outbursts and attempting to influence the jury and garner some sort of sympathy with them. And I think that there was a level of frustration that would have happened at some point anyways. I can't condone it to the extent that any comments were snide comments made toward the defense, but to the extent that they would have deprived defendant a fair trial under the prosecutorial misconduct analogy here, the jury wasn't present for any of those comments. So there's nothing that they would have done to impact the defendant's fair trial in that sense. So, and furthermore, they're not preserved. There was no objection to any of the comments that were made outside the presence of the jury. There were no objections made to the statements in summation as well. So beyond that, unless the board has any additional questions, I'll rest on my papers.
Thank you, counsel.
Thank you.
Case number 7, Mishkowski, MD versus MLMIC Insurance Company. I can't do the math on the Latin numbering there. We'll wait for counsel. Counsel, can you hear us?
Yes, I can. Are you able to hear me, Your Honor?
We are. You might want to adjust your camera just a little bit so we can see you.
I'm working on that.
Very good, counsel. Very good. Counsel, proceed.
Thank you, Your Honor. May it please the court, my name is David Rothenberg. I represent the appellant, Dr. Mishkowski, who was the plaintiff below. The sole question before the court this morning is whether the defendant insurance company has a duty to defend Dr. Mishkowski in response to the allegations in the plaintiff's complaint. So let me start by mentioning some very general principles, all of which are well known to this court. One, the duty to defend is much broader than the duty to indemnify. Two, whether the duty to defend arises is triggered by the factual allegations in the complaint, not by characterizations, not by the way the cause of action is styled. Three, the duty to defend arises when there is a reasonable possibility of coverage. The Court of Appeals said that in the Cook case. And this court has pointed out that when there are alternative theories of liability, questions of indemnification are decided at the time of trial, but not in the declaratory judgment action.
Mr. Rothenberg, could I see if we just narrow the claim a little bit? Do I read your brief correctly to say that you're saying there's a potential claim arising out of professional services rendered, not medical incident? You've abandoned any
Professional services, yes,
So
sir.
medical incident is out?
Well, medical incident seems to describe something other than treatment.
Right. So the policy covers medical claims arising out of medical incidents and professional services. We're just focused on professional services.
Yes, Your Honor.
Okay.
Which is defined as follows. These are acts which the insured performs in the course of treatment of a patient in your or your professional entity's medical practice. So what does the complaint say happened here? And let me direct the court's attention to paragraphs 16 and 39 of the underlying complaint. They appear at pages 137 and 141 of the record. One, the underlying plaintiff was a patient of Dr. Mishkowski. Two, the incident occurred in the examining room at the doctor's office. Three, the incident occurred during an examination of the patient. The complaint alleges that the doctor allegedly touched the plaintiff's vagina without gloves. It also alleges that the doctor digitally penetrated the plaintiff's vagina without gloves. It goes on to say that Dr. Mishkowski allegedly improperly cared for and treated the patient, that he improperly conducted a pediatric examination, and that he failed to give proper and appropriate medical care. All of that appears in the complaint. And based on these allegations, a jury could easily find that the doctor was liable for professional negligence, even if the jury did not find any intentional sexual abuse of the patient. This court has held that if the conduct alleged in the complaint can, quote, reasonably be construed as falling within the coverage, the duty to defend is triggered. The court.
The Chung case that you cite, and both parties cite, and it seems to be very similar factually. The 1995 Fourth Department case.
Yes, the Chung case.
Yes. Not a lot of facts in that decision.
Right, very short.
Have you, I don't know if you looked at the underlying complaint in Chung to compare it to what we have here?
I believe we did it one time, Judge, but I cannot cite it to you at the present time.
Yeah, no, I wouldn't expect. I was just curious as to how you thought they compared. It seemed to me they were quite similar in allegations. We found there was a duty to defend.
Correct. That's
And
correct.
It was 3-2 and it was 28 years ago, but the law doesn't seem to have changed during the intervening period, and Chung would appear to be good authority for you.
I would certainly concur with Your Honor's assessment there, yes, yes. To summarize our first point, if there is a reasonable possibility of coverage for the conduct alleged, then the duty to defend has been triggered. Let me turn to the cross motion by the carrier and allow me to address the issue of exclusion very briefly. First of all, the insurance carrier has the burden on the exclusion, and this court has held that the exclusion applies if the allegations in the complaint fall solely within the policy exclusion. The stuff I just summarized, or not summarized, but pointed out in an argument earlier from paragraph 16 and 39 does not fall solely within the exclusion. The Court of Appeals has actually stated the case, or stated the rule a little more strongly, I would say. The Court of Appeals says that for the exclusion to apply, the conduct must fall solely and entirely within the policy exclusion.
Wouldn't the answer to the first question dictate the answer to the second? In other words, if there's any potential, or is there any facts alleged in the complaint, the four corners, that could potentially provide coverage? Or
Yes.
make a claim for professional services, then by definition, the exclusion wouldn't apply because it has to be entirely within the exclusion. So in other words, if we answer the first question in your favor, we can't help but to answer the second one in your favor.
I would hope that's the case, Your Honor. I'm only pointing this out because it's a different way of articulating the test. I think the result is exactly the same as Your Honor points out.
Plus, the burden is shifting there between
Yes.
those two.
Yes, yes, Your Honor.
All right, very good. Anything further, counsel?
If the court has no further questions, I simply request that the judgment below be reversed. Thank you.
Thank you, counsel. Counsel, proceed.
Good morning, Your Honors. As counsel pointed out, under New York law, the duty to defend is determined by the factual allegations in the complaint against the insured, not the theories of liability or the causes of action that are asserted against the insured. And the Court of Appeals, in Allstate against Mugavaro has held that for purposes of determining coverage, we must assume that what is alleged actually occurred, that it's true. And here, the claimant, Megan Gerga, alleges injury from Dr. Miskachowski's predatory, intentional, and unlawful sexual actions.
Counsel, could I direct you, though, to paragraph 39 of the complaint, of the underlying complaint, paragraph 39.
Yes.
It says between 2010 and 2012, I think when the plaintiff in the underlying action was 10 to 12 years old, she was a patient of the doctor, and during that time, the defendants improperly diagnosed, cared for, and treated the plaintiff, including but not limited to failing to give proper and appropriate medical care and improperly conducting pediatric examination. Those sound in the nature of malpractice, do they not? Rather, as opposed to sexual abuse?
Your Honor, the policy doesn't broadly provide coverage for malpractice. The language of the policy is that it provides coverage for injury because of a medical incident or professional services. And the claimant alleges injury, both physical and emotional injury, from the doctor's rubbing her vagina without gloves and digitally penetrating her at a pediatric appointment. Those allegations do not fall within the scope of coverage of the policy. The claimant does not allege injury from a medical incident or professional services. And her claim for medical malpractice is predicated upon, as are her claims for assault and battery and intentional infliction of emotional distress, are predicated upon those facts of sexual abuse.
So counsel, just so I'm clear, so you're saying you may agree that the complaint, as just referenced by Justice Lindley, does allege negligence relative to professional treatment, but you're saying, but also as part of that, the complaint has to specifically allege damages flowing from the negligent professional treatment, and here the only damages have to do with the intentional sexual misconduct.
That is correct. The only injury alleged is from the sexual misconduct. There's no alleged injury from a failure to diagnose, a wrongful diagnosis, or the negligent performance of a medical exam. There's no injury associated with that. Yes, she alleges that the doctor failed to wear gloves, but candidly, the failure to wear gloves while he allegedly sexually abused her as a 10-year-old at a pediatric appointment, we maintain, does not give rise to a duty to defend and does not render the sexual abuse, the alleged sexual abuse, as a medical incident or professional services.
Yeah, well, that repeated mention in the underlying complaint, several times there's the allegation without gloves. He penetrated her without gloves. The without gloves suggests that perhaps if there were gloves, there might have been medically appropriate. I don't know why you would allege repeatedly without gloves there in that situation for sexual abuse. You just say inserted a finger in her vagina. What do the gloves have to do with it there?
I mean, I think the gloves have to do with it because it's for his own sexual gratification and not wearing gloves, and that she's alleging emotional and physical abuse from conduct that simply does not occur at a pediatrician's appointment. She's 10 years old, and she alleges that he fondled her and digitally penetrated her and sexually abused her. And it was predatory and it was intentional. And she asserts claims for assault and battery and intentional infliction of emotional distress. And yes, there's a throw in for medical malpractice, but as the court below properly found, that does not trigger a duty to defend because the theories of liability are not dispositive. And the cases we cite in our brief, Alaska, as well as Greenberg and Physicians Reciprocal, those cases stand for the same proposition, that You look at the facts and the injury that is alleged.
How
Yes.
specific is the injury claimed in this complaint? We've seen complaints where someone's rendered sick, sore, lame, and disabled, and that's sufficient. Is there something real narrow here?
Well, she alleges emotional and physical injury due to the predatory, intentional, and unlawful sexual actions of the doctor, and then goes through and details what those actions were.
So you're asking that we take physical injury and view that very, very narrowly when that's not what the complaint does?
I'm asking you to view the complaint as alleging injury due to sexual abuse, as the claimant alleges in the complaint, and that a throw-in of a negligence allegation or a medical malpractice claim based upon factual allegations of sexual abuse at a pediatric appointment are not enough to give rise to coverage.
So you want us to read the complaint in a way that, as you argue, all of the damages as alleged, and the only damages as alleged in the complaint, flow from the battery and the sexual assault. There's no allegations in the complaint that there are damages flowing from the professional services negligence claim.
Correct, because there's no alleged injury from that. Again, there's no alleged injury from a failure to diagnose or an improper diagnosis. The alleged injury, both physical and emotional, is from the alleged abuse. And
We'll take a look at that, counsel. I think we have that argument.
Thank you. And then separately, even assuming that there's potential coverage under the policy, there is a sexual abuse exclusion in the policy that broadly precludes coverage for any alleged liability arising out of assault, battery, sexual abuse, undue familiarity, harassment. And under New York law, even in the context of an exclusion, arising out of is broadly construed to mean incident to or having some connection with, and the courts have employed a but-for analysis, and the court properly found that but for the sexual abuse, the alleged sexual abuse, there would be no liability. And for that reason, the sexual abuse exclusion separately applies to preclude coverage for this claim.
We'll take a look at that, counsel. Thank you.
Thank you.
Case number 8, Nationwide Affinity Insurance Company versus Silva Acupuncture PC. Mr. Hollander, can you hear us?
I can. Good morning, Your Honors.
Good morning. My understanding is the appellant is submitted. Do you want to be heard?
Only if the court has, questions this morning. We didn't realize submission until late last week.
I don't believe we have any questions.
Okay.
Thank you, counsel.
All right, thank you. Have a great day.
Case number 9, Adirondacks White Lake Association versus Adirondack Park Agency. We are all live and in person on this one, right?
Yes, we are.
Very good.
Good morning, Your Honors.
Good morning, counsel. Proceed.
My name's Christopher Amato. I'm representing the appellants Adirondack White Lake Association and Protect the Adirondacks on this appeal. Once upon a time, there was a rock quarry that was operated in the southwest corner of the Adirondack Park. In the 1930s, the rock quarry was abandoned. And in the nearly 100 years that have passed since that abandonment, a substantial residential community has grown up in the area, which consists of hundreds of residences. Some are seasonal, some are year-round, and Many of them are members of the Adirondack White Lake Association. Some of those homeowners are here in the court with us today. The attraction of this area is White Lake itself, which is about a 97-hectare body of water that is one of the purest and most pristine bodies of water in the Adirondack Park. The bed of White Lake is owned by the people of the state of New York and is therefore part of the constitutionally protected forest preserve. The area surrounding the residential community is made up of forest land. Some of it's privately owned, some of it's owned by the state of New York. But the area is bucolic, and industrial uses are completely absent from anywhere in the vicinity of the White Lake community. All of this is in the record. In 2021, a company named Red Rock made an application to the Adirondack Park Agency to begin conducting industrial mining operations at the site of the abandoned quarry. In connection with that application, they prepared a noise impact analysis. And that noise impact analysis concluded that the noise from the new industrial mining operation would be unnoticeable, that the mining operation could come in and operate and it would be as quiet as the forest that exists there now. Nobody would hear the drilling, nobody would hear the blasting, nobody would hear the on-site rock crusher that was going to be operating, nobody would hear the 20 heavy-duty truck trips a day that would be going in and out of the site.
Up to 20.
Up to 20, Your Honor,
Could be,
that's
they
correct.
estimated far fewer. They said that we anticipate maybe 5, but up to 20, I'll give you that. But the way that the respondent looks at this is that they had their noise analysis, which said the noise would be no more than, say, light traffic in the area. They say that you, in response, you had an analysis from the LA group. The LA group did not do their own noise analysis, and they say you haven't submitted any analysis of your own to challenge theirs. You're just trying to poke holes in theirs, and you haven't done any separate analysis, and therefore there's no hearing necessary. Do you dispute that you didn't do a noise analysis, or is that just not necessary to get a hearing in this case?
It's absolutely not necessary, Your Honor. The point at which we would conduct our own noise analysis is when it goes to adjudicatory hearing. What the state is trying to do is to impose an onerous burden on the public, saying, oh, you have to do an entire expert, what amounts to pre-filed expert testimony, and submit that to us before you're entitled to an adjudicatory hearing.
They look at it kind of like summary judgment. You got to raise an issue of fact of sorts. That's the way they look at it.
That's how they look at it, but that's contrary to what their own regulations specified. And the Adirondack Park Agency regulations clearly set forth 8 specific criteria that the park agency is required to look at when determining whether or not to hold an adjudicatory hearing. Nowhere in those criteria does it say that proponents of an adjudicatory hearing need to submit pre-filed expert testimony. It's simply not a requirement. And it's entirely adequate for experts to show that the analysis that's submitted by the applicant is deeply flawed. And that's exactly what happened here. The applicant concluded that there would be absolutely no difference in existing ambient noise levels when this mine starts operating.
I appreciate that point, and the baseline wasn't actually measured, which I thought was a strong argument until I looked at the map. I have the map of how Route 28 comes right around the east side of the lake and actually is between the lake and the quarry site. And I couldn't help but think, I guess akin to Justice Lindley's questions, why didn't any of the homeowners get a decibel meter and measure? Because if they measured it and the baseline was quite a bit less than what was assumed under the DEC policy, I guess, or standard, then why wouldn't that have been part of the comments that were made, saying, well, wait a minute, we measured, it's not 58 decibels of ambient noise as a baseline, it's, 36, 25, whatever.
That would have been done as part of the submission in an adjudicatory hearing. But it's the applicant who bears the burden of proof to show that their project meets the requirements of the Adirondack Park Agency Act. It's the Adirondack Park. This isn't somewhere, some industrialized area where a mine's going to come in and nobody's going to notice. There are no industrial uses in this entire vicinity. And this company wants to come in and start a massive industrial mining operation. Is claiming that it's not going to make any noise, that nobody's going to hear a thing. It just defies credibility, and I think that was made clear by the comments of at least one member of the APA board who repeatedly expressed deep skepticism that this mine could operate and the homes that are merely a few hundred feet away aren't going to hear a thing. And keep in mind, this mine is going to operate 6 days a week, starting on April 1st and going right through the end of October, the time when most people are outdoors. They're enjoying White Lake. They're enjoying the forests in that area.
You mentioned something earlier about the burden. Who has the burden here to establish the right to a hearing? Apparently, the APA, they don't hold hearings very often. They haven't had one in decades. And they say the reason they do that is they do their due diligence in the beginning and they make sure everything's okay, and so there's no need for a hearing. But they claim that your clients had the burden under Executive Law 8093D. And they say that the statute requires you have the burden of raising, quote, substantial and significant issues. You earlier said they had the burden. If you had the burden there to your clients to show substantial and significant issues, then the burden's on you. You didn't submit any evidence of your own on noise or traffic or water. Those seems to be the main concerns. Therefore, you're not entitled to a hearing. How did you raise significant and substantial issues without submitting any independent evidence of your own?
By showing that the applicant failed to meet its burden of showing that its project would comply with the requirements of the Adirondack Park Agency Act. Their noise analysis was deeply flawed. Our experts didn't have to come in and say, hey, we've done our own noise analysis, and look, this is really going to be a noisy operation. It's entirely sufficient to show this noise analysis has some very significant, deep flaws, and one of them, as Justice Novak pointed out, is that they made a conclusion based on the effect on ambient sound levels without ever having gone out and done a single measurement of what the actual ambient sound levels are out there.
So Counselor, you're saying that we don't need to bring experts in. All we have to do is literally pop some holes in their application, and once we do that, it's sufficient to require a hearing. And we're entitled to a hearing simply by knocking some holes into their application. Is that your argument essentially?
No, it isn't, Your Honor. The argument is that we do have an expert. We submitted an expert report from an environmental consulting firm that the state acknowledges as a prestigious environmental consulting firm. This wasn't just, people who are anxious about the prospect of a project coming near their home, writing letters saying, we think this is a bad idea.
But did the report have any independent noise analysis? LA Group's report that you submitted.
It didn't because it didn't need to.
It was not signed by an engineer. The report had no indication, no proof, I should say, no affirmative proof of any undue adverse environmental effect. That's fair to say, correct? The LA Group's report had no independent evidence of any adverse environmental effect. Yet you say that report entitles your clients to a hearing. I'm not saying you're wrong, but I'm just trying to make sure I understand what your point is.
Well, first of all, the report was signed by the LA Group's Director of Environmental Sciences, who has extensive experience in all sorts of environmental impact reviews. So this wasn't somebody who was unqualified. This is an individual with decades of experience reviewing complicated projects. And the whole purpose of the review was to analyze the environmental impacts and to critique what the applicant had done. And the respondents claimed that somehow it was the burden of the homeowners and Protect the Adirondacks to submit before any hearing what essentially is expert pre-filed testimony on noise levels and groundwater impacts. is nowhere in the statute. It's nowhere
You're
in their
saying that you
regs.
have that evidence that you're ready, willing, and able to present at a hearing.
Absolutely. We
Well, why
would go
wouldn't you-
forward
Why
with
wouldn't
that.
you bring that forth in the request for a hearing? Why wait to the hearing? Why not say, look, this is what we have, that's what you have, if there's a conflict here, let's bring it before the APA?
Because it's sufficient to show that the applicant's analysis is deeply flawed. If an applicant comes in and says, hey, we're not going to have any impact on noise levels here, and here's why, this is how we reach our conclusion, it's entirely acceptable in terms of, meeting the criteria for an adjudicatory
I think we
hearing.
have that argument, counsel. I think we
Okay.
understand what you're saying.
So-
Anything further?
Yes, I would just like to point out that the APA board depends on the APA staff to provide them with the information and the legal framework for making their decision. The board doesn't meet on a regular basis. They meet irregularly. And in this case, the APA staff failed to inform the board that over 3,000 public comments were received in opposition to this project. And
So I'm looking at the transcript, page 78 of the transcript, where Mr. Korn discloses that there were 314 individual comments, 1,432 form letters, 1,400 petition signatures. He disclosed that.
I think he disclosed that to the Regulatory Affairs Committee, Your Honor, and not to the full board.
You seem to take a pretty dim view of the qualifications of the board members. You say that that the staff never said, well, these are the criteria for a hearing under the regulatory provision there. And you're assuming that the board members don't know any of that, right? You don't know for sure if they have, these are folks, 3 were appointed by the Department of Environmental Conservation, the other were appointed by the governor, they sat on these. You're assuming that they're totally ignorant of the statutory and regulatory responsibilities.
Well, there's nothing in the record to indicate that they knew that there were 8 regulatory criteria that were supposed to be applied. The staff never brought it up to them. In fact, the staff gave them the wrong information. The staff said, well, the only standard you need to be concerned about is whether there are unclear facts. And in doing that, they boiled 8 regulatory criteria into a single unclear facts standard, which doesn't come from the statute, doesn't come from the regulations. And I think the board should have been aware of what those 8 criteria are, because this court has previously held that when an agency fails to follow its own regulations, that is per se arbitrary and capricious. And that's Legg v. Eastman Kodak, which is cited at page 17 of our brief, page 16 of our brief.
But the statute says substantive and significant issues. And that's essentially a paraphrasing of what the board was told. And the regulations, they don't say that any one of those 8 factors can sway. They don't give any description as to how those regulatory factors can be applied.
That's correct, Your Honor, but the regulations also don't say that you need to meet at least 2 or 3 or more of these criteria. So it could be just one of those criteria, and one of them is, for example, the possibility that the project can't meet the criteria for approval. And the Act requires the agency to consider the context of the project. And the idea of citing a major mining industrial operation in the midst of a residential community is something that the Act requires be weighed very carefully by the agency. And they simply did not do that in this case.
Well, I just have one question. Wouldn't the lack of the CEQA review and the degree of public interest, wouldn't that require a hearing?
That's what our argument is, Your Honor.
I was going to ask the other side.
Yeah, I mean, seeker requires that an environmental impact statement be prepared for a project of this magnitude and this complexity.
Well, they say they're exempt under the law, that the APA, because they had even more stringent requirements, therefore they don't have to comply with secret.
But the APA...
That's not correct?
That's correct, but the APA can require an EIS regardless. There's nothing that says the law specifically allows the agency to require an EIS if it believes that one is necessary. And so what seeker assumes, and the reason that APA has that exemption, if it chooses to exercise, is that there's an assumption that the agency's review is going to be at least as stringent as a project review that happens under seeker. And there's just no way that the review that was undertaken of this project measures up to the type of review that's done under seeker.
You should wrap up, Counsel.
Well, thank you, Your Honors. For all the reasons that I've just stated, we believe that the decision of the court below should be reversed, the permit should be annulled, and this matter remanded to the park agency for an adjudicatory hearing.
Thank you, Counsel.
Good morning, Your Honors. Lucas McNamara on behalf of the Adirondack Park Agency. APA properly issued the challenged permit here where petitioners failed to meet their burden of establishing a substantive and significant issue that would require adjudication. The APA has issued more than 200 mining permits for mining activities within the Adirondack Park, and this project proposal, which was to mine dimensional granite, which is large undamaged pieces of granite from a 5.2 acre excavation site, is relatively simple and small compared to other mines in the park.
A lot less blasting with dimensional quarry. There's a lot less blasting.
Yes, that's right.
And crushing. But is this mine operational now?
No, it is not, Your Honor. It is perhaps not received all of the local or DOT approvals. It's outside of APA's jurisdiction, but APA is aware that it's not yet operational.
The main concerns seem to be the noise and the threat to the water aquifers, to the water supply. I know there's talk about the trucks and who owns the road and so forth, but those are the two main environments. Is there a remedy if you're wrong, if the APA is wrong on the noise or the water? Let's say the mining operation gets up and running this year and people do noise testing and it's above the whatever decibel, 32 decibels you estimated, and it's louder than anticipated, or the water supply is breached. Is there a remedy then? Does the mining operation does the permit get pulled?
So APA has robust enforcement authority to hold the applicant to its mine plan proposal. So what that would mean is that, for example, on groundwater, the applicant is strictly forbidden from intruding on the groundwater. I'll set aside the testing requirements for now. If they were to do that, they would be in violation of their permit and APA could take enforcement action. Moreover, let's say they're operating more machinery, louder machinery, than was anticipated by the proposal before APA, the APA approved. They could also take action there. If under APA's analysis, the noise is simply different than anticipated, it would come up during any future mining permit renewal. That being said,
so I think so is the answer. I just want to understand the answer to the question. Is the answer to the question that the ability to go in and enforce, say, rescind the permit once it's approved, if the decibel level is higher than what was anticipated? You're saying we have to wait till the permit expires, and then on the reapplication process, that's when that information becomes available.
That's accurate. As a matter of statute, that's the power that the APA has. But as background to that, I would remind the court that in this proceeding, APA used a DEC sound policy that DEC and APA have been using for approximately 2 decades. Despite petitioners' broadside on the use of that policy and the recommendation that they rely on some sort of unscientific common experience, there is no evidence in this record that in even one permitting proceeding, someone like petitioners or further study indicated that this DC sound policy did not protect nearby residences. And if you read the policy, one of the reasons that's true is unlike taking actual ambient sound levels, there's all sorts of conservative assumptions built into the policy to protect nearby residences. And I would say that that's evidence of that. There is no proof in the record that the application of this policy has ever led to a permit that says, we're going to engage in this activity, and it turns out that this activity actually causes undue adverse noise impacts. So that's a 2-decade, hundreds of permits record in which, the evidence before this court is essentially that the application of that policy is, 100% protective.
Counselor, as I understand their argument, you're saying you skipped a step. that if they raise these issues in this special place, the Adirondack Park, you're supposed to have a hearing. I mean, ultimately, the permit may be issued or it may not be issued, but you shouldn't issue the permit before you have a hearing. And the purpose of Section 809 is to allow the public to voice their concerns and force the agency to actually air it publicly.
Sure. That's not a particularly accurate representation under the law for a couple of reasons. Under case law.
That's their argument.
Sure,
right?
yeah. First, I'd like to.
So how did they not, on this record, at least raise the issues? Not resolve the issues, but raise the issues of noise and potential water contamination?
Sure. So what petitioners have argued today is that they poked holes in the application. Their argument is that, particularly on appeal, that the wrong ambient noise level was used in regard to highway noise, that they should have not used the average that they used. However, first of all, APA's licensed engineer submitted a affidavit saying that the estimate of 58 decibels of noise impact from nearby Route 28, which is a section of roadway where 2,500 vehicles travel a day within 50 to 100 feet of these residents, was an accurate estimate. Moreover, even if the applicant had used the lower bound of light auto traffic, so I mean that would be a pretty inaccurate description of 2,500 vehicles a day, but even if they had, before considering how vegetation would attenuate noise, which would be another 15 to 20 decibel reduction, right? The applicant simply left that out of their analysis. Even then, if you use the lower light automobile, the ambient noise level would be 50 decibels. The applicant's noise analysis would show that its activity would be 53 decibels. Under DEC's noise policy, raising the decibel level by 3 decibels would be unnoticeable to tolerable, so clearly not an undue adverse impact.
When was the last adjudicatory hearing that the APA held? How long ago has it been?
It was in 2007.
So we're 16, 17 years, and not a single hearing. And there's a provision for these hearings under the law, 809, the executive law, and I can't help but to tend to agree with the petitioners that it seems to be the policy of the APA here to not hold any hearings, unless they know they're going to deny it. But for something they think they're going to grant, they don't give a hearing. Why not give people a voice at the hearing? What's the downside to letting everyone be heard before you issue a permit of this magnitude that has such a significant effect on their lives? Why? It just sounds like it's a blanket. We're never going to have a hearing here.
No, Your Honor, that is not the APA board's policy at all. The Lohr affidavit from the Deputy Director of Regulatory Affairs that we submitted with our return addresses this issue. The last hearing that was held went on for years, involved multiple rounds of litigation, was both time-consuming and expensive. APA staff works with applicants during the pre-application stage to make sure that their applications are complete. Since that time, applicants have been much more willing to work with staff to address deficiencies in the application, or much more aware that given the stakes of a staff recommendation that if the APA board deny a permit, that they simply withdraw their permit application due to the expense that they could incur. So it's not a simple process at all. This is fully set forth in the third department cases that we cited addressing this, that it can be years of process. There were, I believe, 29 or 39 parties in that last adjudicatory hearing. And under the regulations, the way that public interest is weighed, and certainly there was significant public interest here, is it is weighed against the opportunity that is provided to the public in the absence of an adjudicatory hearing. Now, it's important to consider the baseline here. Under the Adirondack Park Agency Act and related regulations, if there is not a waiver from the applicant, the APA board needs to make this decision within 60 days. That means the public comment period is 15 days by regulation. So what happened here? APA staff worked rigorously to get a waiver of that provision so they could provide a 9-month public comment period.
Right, counsel. It seems to me that the purpose of an adjudicatory hearing is not to allow the public to air concerns. That was done here because we had the extension of time in the 9 months, and we had a lot of public concerns that were presented along with the expert report in opposition. The purpose of the hearing is to resolve substantive issues, significant issues, and ultimately the board didn't find that. Is that your understanding?
That's exactly right. So an adjudicatory hearing is much, like a trial before a court, ruled by formal rules of evidence. There's no rules like that whatsoever. You can submit public comments regarding your policy preferences. You can submit public comments on whatever issue you want, and the public did so here, and the APA board considered all of those comments, including a report that was alleged to be an engineering report that simply wasn't signed by a licensed engineer. APA nonetheless considered it. It's not even clear that that could happen in an adjudicatory hearing.
Now that being said, though, on the substantive issue, we talk about the groundwater for just a moment.
Yes.
5 feet above the water table. And I know that Ms. Brzezinski explained that, we're going to have 2 years of monthly groundwater monitoring pursuant to, I think, the DEC permit. But there were a lot of questions raised, it seemed at the regulatory hearing at least, about, well, wait a second, what if the water table goes up or down, or periods of drought, and how that affects? And it seemed to me that there were significant issues raised, at least by the board members that were present. I think 9 were at their regulatory affairs meeting. Why wasn't that enough of a significant issue to then justify the hearing?
Well, certainly significant issues were not raised by the board members who were asking tough questions and then unanimously voted to grant this permit, right? So much like this court asked tough questions, they were satisfied with the answer. So the requirements under the DEC permit, which are incorporated in the APA permit because they have to provide these water table reports to APA, make sure that there's 24 monthly tests before they can excavate anything below the current mine floor at the point where they start excavations. So that's 30 feet above the estimated high water level. So it's not until 24 months of testing occur that happens. Even after that, so and what is that 24 months of testing? It means that the highest groundwater level, the highest water table level, right, whatever the highest of those 24 data points is, that's baseline is the assumption from which you have to stay 5. So it's not a median, right? And then sometimes 5 feet above won't be enough. It's taking an incredibly conservative estimate of how high the groundwater gets, and then 5 feet above that. That's within APA precedent. Moreover, in relationship to the comment that the mine is not yet operational, if the mine is not operational within a year, they simply won't get out of. They'll be testing every month for the entirety of the permit, right? And as a final point on that. Petitioners in their opening brief said there's no way for the petitioners, but for this requirement, there's no way for petitioners to even know whether they intrude on the groundwater. But that's obviously just factually false. The way that they're going to test this is they have a well on site that they used for the diamond wire saw that they need, right? They have a strict requirement that if they intrude on groundwater, they will violate their permit and they will be subject to civil penalties. Even after this 24 months, all they have to do for their own interest, right, their own legal interest, is to continue to periodically test if they are concerned, because they are held strictly liable, right, to not intrude on the groundwater. So it's not that if there's no testing requirement from APA or DEC, and again, there is 24 monthly tests. If you were to look at the administrative comment from the LA group, they said it's a problem that there isn't testing as to the height of the water table. We would like APA and DEC to impose the testing that it believes is appropriate. Now in their reply brief, they say 24 monthly tests isn't enough. I mean, that's not administrative exhaustion, right? I mean, they needed, if they believe this wasn't enough, they needed to specify what DEC and APA should have done. Waiting for reply is too late. Related to that issue, today petitioners have told you about the expert proof that they would supply at an adjudicatory hearing. That's literally the first time petitioners have ever said that. There was no comment before the APA board that they had any evidence to produce in an adjudicatory hearing, let alone an excuse for why would you not produce it during the 9 months. So there isn't some sort of hide the ball criteria where you're rewarded for letting the APA believe that you've submitted all of your expert evidence, but then waiting for an appeal before the department to claim that you could have produced expert evidence to create a material issue on groundwater or noise level.
I think we understand that, Council.
So it's not only that they did not provide those reports, they didn't even say that they would if there were an adjudicatory hearing. That's been said for the first time today.
You should wrap up, Council.
Yes. Is just a final point on the noise. The issues that are of incredible importance in relationship is that the ambience noise level is not related to the forest, which petitioner said. It's related to a highly trafficked thoroughfare directly next to these houses. And the reason that the noise impacts are mitigated to such a great degree is because there will be a 30 to 60 foot mine wall between the mining activities and the nearby residences. So imagine, if I were not mic'd and there were a 30-foot wall of granite between us, that is the most significant factor for why there will be no undue adverse noise impacts. With that, I would ask this court to affirm the trial court judgment dismissing the petition. Thank you, Your Honor.
Thank you, counsel. Case 11, Adam Williams versus Dowdell.
Are you able to hear me?
We can hear you, but you haven't come across on the video yet.
Yeah, I apologize. I'm trying. I'm getting an error message that it says I cannot start my video.
Okay, well, we can hear you, counsel. If that's, you can proceed without the video.
Okay, very good. Thank you, Your Honors. May it please the court, Martha Donovan on behalf of defendant appellant Ann Dowdell. I'm here to ask this court to reverse the decision of the trial court, which denied our motion to dismiss plaintiff's claim for punitive damages in this action. Punitive damages are the exception, they're not the norm. And it's our position that plaintiff is using this claim for punitive damages to levy some perceived advantage over defendants. As mentioned in our brief, since 2020, Plaintiff's counsel has commenced 24 personal injury actions and has included a claim for punitive damages in all 24 cases. In the instant action, the allegations are that the defendant failed to stop at a stop sign. There's absolutely no evidence in the record or in plaintiff's opposition to support any claim that the defendant's actions were in any way willful, wanton, or deliberate disregard.
Counsel, could I ask you this? What advantage is the plaintiff gaining through discovery of having this punitive damage claim at this point? You say that they're doing it for strategic reasons. How does this affect the discovery process, having this claim out there, in your view?
In our view, it changes the conversation that we would have to have with the client, and to let them know that there's some potential for this personal financial contribution that may be levied. And it's a tactic to intimidate or frighten defendants from the outset of the litigation. And it heightens their sense of vulnerability that shouldn't be present in a negligence action.
Don't you sometimes, if there's a case of a severe injury, have to still have a conversation with a client about the fact that the coverage might be insufficient?
It is true that we may potentially have to have such a conversation. However, in those instances, there is still some possibility that the insurance could cover those claims, whereas in a punitive damages claim, there's absolutely no availability for insurance coverage in those instances.
Are you saying, counsel, just so I understand, are you saying that except in punitive damages claims, if the damages are levied above the policy limits, that the insurance company would step up and cover it?
In some instances, insurance companies do cover the excess, or they are negotiated down. In a punitive damages case, however, there's absolutely no option for the insurance to even address those issues.
Well, counsel, you were asked a question about how you might guide your client, but I want to get back to the point you make in the brief, and that is, in order to maintain a demand for punitive damages, you have to allege facts that would support culpable or morally reprehensible conduct. That's your point.
That's correct. And the
And
Barnes
so
case,
where in this complaint is there any allegation of morally culpable conduct?
there isn't. It's the plain boilerplate conclusory allegations that the first department rejected in the Barnes case. It's in plaintiff's complaint. He just alleges that the defendant operated her vehicle with complete indifference and disregard for the safety.
Counsel, wouldn't those facts that we're talking about, I mean, we're talking about a situation here where somebody's operating a vehicle, right? And the allegation is that there's a failure to abide by a traffic control device causing an accident, right? Do I have that right?
Yes, a stop
Yeah,
sign.
yeah, and so what's happening inside the car itself? You know, in other words, just hypothetically, whether the driver has taken some maybe medication that they weren't supposed to be taking, is intoxicated, we're doing some activity with their phones that they shouldn't have been doing. All of that would be in the control of the defendant, would it not?
That's correct, Your Honor.
Yeah, and don't you, counsel, also in your papers make allegations in the affidavit concerning the fact that I think the driver saying that they weren't intoxicated and they weren't using their phone, and isn't that a factual inquiry that you're relying upon in seeking to have this cause of action stricken?
Yes.
Well, if it's a factual inquiry, shouldn't the other side have an opportunity to examine that?
Absolutely. But the proper procedure for doing this would be for plaintiff's counsel to ask these questions during depositions. And if the depositions led to factual conclusions that there was some support for any sort of allegations that would support a claim for punitive damages, then the complaint could be amended at that time to...
Didn't the trial judge in this case deny your 3211 motion without prejudice, with the idea that those kind of inquiries would be had, and then if there's a motion for summary judgment at the end of this, that motion could then be filed, and this cause of action, or this claim for damages, punitive damages, could be stricken?
The trial court did, Your Honor. However, it's our position that the holding in the Barnes decision holds the plaintiff to a higher standard for making and supporting a claim for punitive damages, and that plaintiffs are not afforded the same level of deference in a motion to dismiss a claim for punitive damages that they are with respect to other types of claims. And that's
Ms. Donovan, can I ask you this? This was a motion under 30, it was a motion to dismiss for failure to state a cause of action under 3211A7? Is that right? 3211A7 says it's a motion to dismiss somebody's cause of action, right? It's a cause of action you're seeking to dismiss. Now,
Yes.
punitive damages is not a cause of action, correct? I mean, the case law is replete. There's a claim for punitive damage is not a cause of action. 3211A7 is to dismiss a cause of action. I was looking at the case law on that. I'm not even sure that's the right vehicle to dismiss a claim for damages. Have you looked at that? I know there's some case law that does it here and there, but it doesn't seem to even fit in the first place.
Well, it's our position that the courts have found this to be the appropriate section of the CPLR under which to dismiss such claims. This was the basis for the grounds of dismissal in the Barnes case, in the Crosby case, and also in the Weber case. So it's our position that this is the appropriate section of the CPLR.
Counsel, should we be concerned that if we were to grant the relief that you're suggesting and say, no, we're going to dismiss, none of these allegations about punitives until you have a factual basis, could that give rise to plaintiffs filing complaints in cases like this where it's just limited to running stop signs, where they then speculate in the complaint and say, well, we're going to allege upon information and belief that the person was texting, that the person was drunk, that the person was high, et cetera. And we end up with these complaints that have these laundry lists of allegations that then have to be gone through. But is that what comes next?
I mean, I think potentially, because it's our position, and the courts are consistent on this, that punitive damages are the exception and not the norm. This is not a claim that should be asserted in every single personal injury action. Even in the cases where it does apply, the conduct has to be so egregious. And it isn't applicable everywhere, and it should not be included everywhere as a matter of course.
Thank you, counsel. Anything further?
No, nothing, Your Honors, unless you have additional questions.
No additional questions. Thank you.
Thank you very much.
Case number 12, Carrie K. versus State of New York. Very good. Counsel Chamberlain, can you hear us?
I can. Can you hear me okay?
And we can hear you also. Counsel, is it Raimondi?
Raimondi, yes, I can hear you.
Raimondi, and we can hear you very clearly. Counsel, please proceed.
Thank you, Your Honor. May it please the court, I'm Patrick Chamberlain from Mental Hygiene Legal Service on behalf of the appellant, Carrie K. As Your Honors are aware, this is a Mental Hygiene Law Article 10 weight of the evidence appeal. I wanted to begin by discussing the level of deference that this court should afford the lower court in this matter. Typically in these battle of the expert cases in Article 10, this court affords considerable deference to the trial court and their ability to review the witness testimony and review the exhibits. Here, I think the circumstances suggest that Supreme Court did not really actually consider the witness testimony. You had a full day hearing that produced 200 pages of testimony, 400 pages of exhibits. Within less than 24 hours, the court had churned out a 12-page decision that made no reference to any of the testimony, no reference to any of the exhibits other than the expert reports that had been available for months. The decision was primarily block quotes from those reports that were months old. No meaningful consideration of the clarification that was provided at the hearing with respect to aspects of those reports through the testimony, through the documentary exhibits. So although there's typically deference afforded here, I would submit that that same level of deference should not be afforded under these particular circumstances.
The trial judge did say he credited Dr. Hackworth. Credited was the word he used. Were there any credibility determinants to be made here? Any credibility questions? I don't see any of who was telling the truth, who's not telling the truth. It's not credibility so much as persuasiveness. You have two very experienced and qualified experts, they don't agree. So who settles the tie? A non-expert. And so it's really not credibility. Am I right on that?
Yeah, I mean, I guess it's a matter of semantics, really, what you want to call it. But it certainly, I will recognize that the judge did, I guess, go along with what Dr. Hackworth said and accept her testimony over the competing testimony of Dr. Bard. It struck me that it did not seem that there was much consideration given to the testimony itself. That there was a lot of clarification that was afforded by that testimony. And
well, counsel, you're just so I understand, you're beginning your argument by saying that we shouldn't be giving the trial court the deference we normally would be giving the trial court in this kind of case. Is that where you're starting?
Correct.
Yeah, and Justice Lindley made the point that it's not really a credibility determination as he sees it, and I tend to agree that there didn't seem to be challenges to credibility being posed, but rather just which experts' evaluation of the facts, which doesn't go to credibility, which I think maybe lends to your argument that, you know, the judge wasn't making credibility determinations at the time of the hearing, right?
I think that's correct. And I'd also add, you know, we had mentioned in our brief with these weight of the evidence reviews, this court has as broad authority as the trial court does. So
I just want to make the point, you indicated, and I wanted to make sure I was on the same page as your argument. You indicated that it's semantics, but I don't know that it is semantics. I think there might be some real difference there, that if we're not doing a credibility determination, then maybe we don't give the deference to the trial court that we might otherwise give.
Yeah, I think that's a fair point, and I'll take that. Moving to the merits itself, on the way to the evidence points, just briefly with respect to this question of predisposition for mental abnormality and strong predisposition for purposes of the dangerousness question, a couple of points. First, the evidence was clear that Mr. Kotler did not meet the threshold for psychopathy, so there was not a separate condition, disease, or disorder for the court to consider in addition to the antisocial personality disorder. Our position is also that on these particular facts, there was not a distinction drawn between Mr. Kotler's particular traits of antisociality and his particular traits of psychopathy. The evidence here was that the DSM-5 treats them as synonymous, that psychopathy is an associated feature of antisocial personality disorder. There was 4 scores, the average of which was a 25.7 that put it within the margin of error for the average score for criminal offenders. So it didn't really differentiate him.
With respect to the last point you made, the distinction between ASPD and the psychopathy, I mean, that was a debated issue. I mean, Dr. Hackworth indicated that psychopathy affects a smaller proportion of the population, looks at factors not relevant to ASPD, such as lack of empathy, remorse, and guilt, all of which were relevant here in this particular situation. Why should the court have not credited that testimony?
So she did testify to that effect. She also testified that there is overlap as well. So she testified, for instance, that factor 2 traits on the PCLR and facet 4 traits specifically correspond to antisocial personality disorder. And the reason that's relevant is because on her scoring for Carrie K, 15 of the 27 points she assigned were under that factor 2 section of the PCLR. So our position here is not that psychopathy or psychopathic traits can never be enough to be an add-on diagnosis to antisocial personality disorder. It's merely that on these facts, it was not proven to be distinct, and they weren't proven to be something that differentiate him from a typical criminal or have a strong sexual component, all those things the case law requires. With respect to the question,
it would seem, from my reading of the record, that these assessments, they're very subjective. Would you not agree? Matter of fact, we had 2 experts on a prior hearing who diagnosed sadism, sexual sadism. I don't think either of the experts this time around did, right?
Correct.
So we had a prior hearing the first time around who found him not dangerous enough to be confined. That was the court's finding. He was released to assist. He appealed the mental abnormality, and then he ended up confined. This case you could have any number of qualified people look at the same individual, the same records, and people are coming up with all sorts of different conclusions on all sorts of different issues, and the result is we're confining somebody, significant deprivation of somebody's liberty based on these subjective determinations that the experts can't even agree on. And who decides? Again, who decides? Non-experts like us and the trial.
I couldn't have said it better myself, Your Honor. I think that is part and parcel of the problem with Article 10 generally, but also looking at the facts of this particular case. There has been a great deal of diagnostic uncertainty, a lot of disagreements among the experts across the long and tortured trajectory of this case. And even Dr. Barr did speak to that in his direct examination testimony. He talked about, with the PCLR in particular, but it goes beyond that, the subjectivity that's involved here. And I believe there's one study that was put into evidence that showed, raised questions about inter-rater reliability on psychopathy. Goes to show that 2 experts looking at the same facts can reach very different conclusions. So that's a point well taken, Your Honor.
Also, let me ask you this. We don't often get, we get a lot of these cases, but we don't often get cases, which I think this one presents us with, where the petitioner was actually released and out for 18 months and didn't offend, right? And one of what we're trying to analyze here on the cyst is, do they qualify for cyst, and would they perform in cyst, or are they incapable, right? I think that's the word, incapable of restraining themselves, essentially. Here we've got 18 months of of conduct that we can look at. We don't often see that. Is that an important factor in to your way of thinking?
It's very important. It's important both with respect to the question of his level of behavioral control and the separate question of risk and likelihood of reoffense. It's extremely rare to have an annual review case under Article 10 where someone has been out in the community and has sort of demonstrated their ability to control themselves in that setting. I think that's a very strong factor here. I think you're going to hear the state argue, and they have argued, and Dr. Hackworth certainly took the position that even though he did not sexually offend while in the community, Carrie Kay was engaging in some sort of creepy and sketchy conduct toward this woman that was talked about at the hearing. Really, even Dr. Hackworth conceded, though, that he never made any sexually inappropriate comments to her. Nothing he did was objectively intimidating toward her.
Well, he was trying to, I'm not going to say the word lure, that sounds a little wrong, but he was trying to persuade her to come alone and meet him in an abandoned building, which is a bit concerning.
I think that
seeing that his past sexual offenses, he's isolated the victims.
I think that's certainly one way to look at it. I think if you look at the totality of everything that was admitted, there's some dispute about that. There was the trial testimony of his ex-girlfriend admitted saying he was assisting her with jobs of that nature. This was not some predatory scheme. He was actually working in that realm, I guess, so to speak. And I think it's also telling that this woman did not begin to accuse him of being a stalker or being creepy in any way until this misunderstanding about her perception that he had ratted her out to DSS about working. So the evidence was that it was they were getting along. There was no concerns until that point. So to Judge Whalen's point, I think that the most important thing and the standard here is he unable to control his sexual conduct? And the worst that can be said, I think, even if you take Dr. Hackworth's opinion that this was predatory in some way and you accept that, the worst that can be said is that he was engaging in this sort of socially undesirable conduct that this court said in George N. is not enough to justify confinement.
Counselor, as far as that incident goes, Dr. Hackworth did not have the benefit of the opportunity to talk with the petitioner here.
That's true. Yeah,
he refused the interview, so that she has to then draw some conclusions from that as well, and evaluate this in the totality of the circumstances.
Yeah, he did exercise his right not to speak with her. My understanding is that there obviously, her and Dr. Bard had access to the same records otherwise, the same underlying trial transcripts.
But isn't that a little bit of the credibility issue that the trial court is faced with to determine whether Dr. Hackworth had sufficient evidence and sufficiently reviewed the materials and had a sufficient process to develop her ultimate conclusion that CIS was inappropriate?
It's certainly one consideration, and I think that's a thumb on the scale for
and isn't it fair to say that the court had the benefit of watching or viewing, I think this was a video of the cross-examination, that there was an opportunity to poke holes at her in her determination, ultimate conclusion. And just to finish up where you started, you wouldn't need days and days and days as the trial judge to evaluate whether or not the cross-examination was successful in terms of poking holes.
I think what I would say to that is that there was a great deal of documentary evidence provided in addition to the testimony, that it seems very unlikely the court had a sufficient opportunity to look at all of that. The only thing that was available ahead of time.
Right, you don't know that. I mean, those reports were in front of the judge for many weeks.
The reports were, I acknowledge that. I'm saying the remainder of the documentary evidence, which was hundreds of pages, it just raises a question about the thoroughness of the court's review of that information is all I'm saying. And it does speak to, I think it's telling that the decision itself makes absolutely no reference to any of the testimony. It's all block quotes from the reports that were, as you said, available months earlier. So I raise that to point out that perhaps the thoroughness of the court's review does not entitle it to the same deference as it typically would be entitled to.
Counsel, you should wrap up.
Yes, thank you, Your Honor. Just finally, I think the court should pay close attention to the fact that Carrie Kay had a combined 18 months in the community without engaging in any sexual misbehavior. The standard under Michael M. is inability to govern conduct. With respect to mental abnormality, I think I made my points that those the traits of psychopathy, which were the only other thing alleged here, were not sufficient to distinguish the antisocial personality disorder or to distinguish Carrie K from a typical recidivist criminal as required by Donald D.D. Thank you.
Thank you, counsel. Counsel, you want to proceed?
Yes, Your Honor. Good morning, Rachel Raimondi for respondent. Your Honors, what this comes down to is a question of whether or not Carrie K is the same person who he was when he entered OMH custody in 2013. He is still obviously controlled by his mental abnormality, and he is a dangerous sex offender requiring confinement. Dr. Hackworth testified at length that the ASPD and the psychopathy are two different personality disorders. The ASPD causes Carrie K to put his needs above others and to disregard social norms. There was testimony that he inflicts pain on women despite them crying, despite them telling him to stop. And then his psychopathy causes him to have poor behavioral controls. He has an admitted need for revenge against women who he perceives as wronging him. And he also has an admitted need for immediate gratification. We also know that he cons and manipulates, which is significant for psychopathy. In the instant offense in 1995, he posed as a police officer with a badge. He lured the victim, he pulled the victim over after she was driving. He lured her to a secluded location where he raped her. And there's evidence that he commits these rapes despite having access to healthy consensual sex, because it's a compulsion and he's unable to control his behavior. So
well,
as a result,
you say the word unable to control, but he did. He was on electronic monitoring and he was on cyst. He was being watched as close as you could possibly watch a human being for 18 months, and he did not reoffend. Isn't that true?
Your Honor, I would argue that he was preparing to reoffend, as Dr. Hackworth testified. He did the same things he's been doing time and again. He targeted a young woman with substance abuse issues. He pretended to be somebody who he's not. So when he was on cyst, he pretended to be a multi-million-dollar construction corporation owner. And he repeatedly tried to lure KZ to an abandoned building
Right,
with
but
him.
one major difference between KZ and the victim in the qualifying offense. Qualifying offense victim was a stranger, and he was convicted based on DNA evidence that ironically had exonerated him previously. This KZ was not, they had been exchanging, they've been communicating for months and months, I think up to 6 months on texts and so forth and so on. That was not an impulsive rape of a stranger, if he was planning on raping her. It's a different situation. He did not, in fact, rape her or engage in any sexually inappropriate conduct with her during the length of their relationship. You're suspecting that he was going to at some time get around to it, but it's a different, the facts and circumstances are different than the qualifying offense where he just met somebody and lured them out into the woods.
Well, I think what's different is that he didn't actually get KZ into an abandoned building because she avoided him. I would dispute that they were texting back and forth. She testified, and her testimony was before Supreme Court, that he repeatedly contacted her and made unannounced visits to her home. As Dr. Hackworth testified, that is identical to his, or it's reminiscent of his previous behavior.
Counsel, I'm so sorry to interrupt. One real small point. Everybody's been saying 18 months on cyst. My notes indicated that he went out on cyst in November of 2017 and then was reconfined in June of 18. Is that wrong? I have 8 months.
No, so the cyst stint in 2017 is 6 months. I think what counsel is referring to is time before that when he was appealing his second department decision. He was briefly out before coming back in. But the most recent, sorry, go ahead.
Oh, that's all right.
Okay, the most recent time that he's been out was only for 6 months, and he did repeat his offense cycle. Your Honors, it is undisputed that he has not engaged in treatment and that he has currently no relapse prevention plan. So before the Supreme Court, there was no reason to believe that he would act any differently than he has always acted. KZ told him to stop. He didn't stop. He persisted. We know that he has the ASPD and the psychopathy, which control his behavior and stop. It disinhibits him from acting on his admitted need for non-consensual sex. Like I said, there's no reason to believe that he would be any different if he was released now. If there are no other questions, I will rely on my brief.
Thank you, counsel.
Thank you.
Case 1314, Tintello versus Clifton Springs Hospital.
Morning, Your Honors. Michael Pretch on behalf of the appellants in this case. I think the material question before the court today is what constitutes willful and contumacious behavior with regard to a discovery motion. I've, read through both briefs, and, the closest thing that I can come to a definition from the cases where pleadings were reinstated after being stricken by the trial court in cases where they were not, is that the, for lack of a better term, offending party had refused to engage in the discovery process, and my submission to this court is that that is just not the case here. There were discovery issues along the way, but at the end of the day, we continued to engage in the discovery process. We did.
There were discovery issues along the way. We had a court order discovery schedule in place. That was not adhered to. You agree on that, right? The first one. I'm talking about the first one.
In 2019?
Yeah. Then there was a second one. Then there was a third one, right? So this is my question. How long a period of time from the commencement of the action to when the answer was stricken had this litigation gone on for? It was years, right?
That's correct, Your Honor.
Was it 4 years or something like that?
Was it 4.5?
I believe it was initiated in January of 2018, and the motion that ultimately struck our pleadings was in March or April of 2020.
And at the time the pleadings were struck, at least a couple of the witnesses, potential witnesses, died, correct?
Not liability witnesses, Your Honor, but yes, there were witnesses that I guess would constitute and, speak as to.
Wasn't there also, as I'm looking at this record, and correct me if I'm wrong, there was a medical care provider that was known to the hospital who had left the hospital. I don't know whether it was terminated but left the hospital. And that information was never provided to plaintiff's counsel, was it?
That's correct, Your Honor. We were trying to reach out to that individual.
Would that individual have been able to have been subpoenaed by plaintiff's counsel had you disclosed to them that he no longer was employed by the hospital?
I believe that is correct, Your Honor.
But they didn't know that, right? They were under the impression he still worked there, and you were trying to arrange for the deposition.
Correct, Your Honor.
All right. These are troubling developments during discovery, counsel, but proceed with your argument.
I understand. With regard to the paper discovery, which is, where this starts, obviously, I would submit that while there were discovery issues, and Your Honor points several of them out, the vast majority of paper discovery was complete in January of 2020. The case then sat stagnant for a period of time. Following January of 2020, there were very minimal disclosures made. There were amendments made to the disclosure tools to amplify clarity, but with regard to actual production, there was very, very little.
Yeah, counsel, look, I read your brief, and it's very well done in your reply brief, and I think this is a relatively close case. And I was persuaded by a lot of the points you made, but I get back to what troubles me is the decision that Judge Doyle issued. It was August 1st of 2022, I think. Judge Doyle was not quick to strike this plea. I think this was the third motion to strike that he finally granted, but on the second one, he wrote a decision. It was basically saying, I'm not going to do it yet, but I'm warning you here. And it detailed that he said, I'm troubled by the dilatory conduct of the hospital. Was troubled, disturbed by the lack of response to various emails. They would email, Thomas's office would email saying, they would just be ignored for months and months. Judge Doyle laid it all out. It was basically saying, I'm not going to pull the trigger now, but be careful, you might get shot. And then it continues. So that's where it makes it difficult for your client.
Understood, and I would love to comment on that, Your
Yeah.
Honor. With regard to Judge Doyle's August 2022 decision, there are a couple of issues that I think colored the context of that decision. One of them was that it appeared that we had given the wrong medical record, and we spent a lot of time at oral argument talking about that. And frankly, that came from a place where when the motion was made in April 2022, and because I had not previously been involved in this, and I jumped on, and I've never been before Your Honors on a discovery motion before, and I just kind of said, here's everything I've got, because that's typically how I handle discovery. I gave a medical record that was for a larger date set, but I did not know that at the time, and I think that really colored Judge Doyle's decision. And understandably, if we had withheld 1,000 pages of medical records that the plaintiff was entitled to and had requested, that would be a serious issue, and I understand that. The second issue that Judge Doyle took issue with was the SIWA assessment, and he really hammers that in that August 2022 decision. The reality is that just doesn't exist. So again, these issues that Judge Doyle took in August of 2022 did not result in further disclosure because disclosure had already been made. And so when we look at these cases like Copen and Stoker where the offending party didn't engage in discovery, it's just not the case here. We provided those documents. They'd had them for years.
Well, on the SIWA assessment, there was a SIWA number of 7 that was given in the medical records, and they wanted the assessment, the underlying assessment, how they got to 7, and instead of saying we don't have one, the response was, well, it's in these medical records we already gave you, which wasn't true. And then they wanted these policies. So the 4 policies and procedures, and there was it sounds like those might have eventually made their way over, but it just didn't seem like there was attention to detail on this. And if you had said at the outset, we don't have an assessment, that would have saved them a whole lot of time and trouble.
So certainly this is looking at this retrospectively is advantageous. I certainly agree. I wish I had done that. When I was looking at it, I was confused as to where the confusion was. And so when I saw that SIWA number, I said, that's in the medical record. And I eventually did clear that up because I cleared it up in open court when we had the oral argument because, again, I came in late, didn't understand. But, again, we're talking about willful and contumacious behavior. Turned it over. When I understood the confusion, I clarified it. And I think that is really with regard to the paper discovery, I think that's the telling issue here is that further disclosure was not really made in any, significant manner.
Counsel, I appreciate that you came in late and that really when you talk about the contumacious behavior, it's the hospital's behavior, not your behavior. But what feels unusual to me about this case is that it's being presented as though it's this big medical malpractice case. We're talking about thousands of pages of medical records, and as though the decedent had all this surgery and a very complicated medical. That's not this case. This is a case where somebody comes to the hospital intoxicated. He's there for 12 to 16 hours, gets released to a snowbank, and dies of exposure. So where's the complexity in the records? The question is, why was he released? What are the policies in terms of when you release somebody? Why is the discovery taken 4 years as opposed to 4 months here? This is a relatively straightforward case. It's more like a slip and fall than it is a medical malpractice case.
So prior to April of 2022, I believe things were coming in piecemeal and they were being sent out piecemeal, which added to the confusion. Again, after that, I would submit that significant disclosure wasn't made. And so while maybe the bow had not been put on paper discovery, disclosure was substantially done. There was the issue with supplementing the 2016 policies. Again, I don't think that you could say that is intentional or contumacious. It was, we gave the policies, they said 2018, 2019 on them, whatever it was. Years later, plaintiff's counsel pointed out that they wanted the 2016 policies and they were replaced.
Counsel, let me ask you this, and please correct me if I misunderstand this, and I may. But as I'm reading the record, it appears to me that part of plaintiff's concern is that they've made specific demands, and they wanted replies to their specific demands. In other words, demand number, 12A, respond to it. Here's the response to 12A. And instead, what they were getting was, we've given you all the records, it's all there. That's, when the argument is we provided everything to them, but you haven't provided it in a way that's responsive. Isn't that a problem, or do I misunderstand the record?
No, I think you understand, Your Honor, and again, that's one of those issues that I spoke to earlier. I agree, this is a thing where I wish I had.
Well, this happened before you were even involved
I
in the case,
understand.
Counsel. You're taking a lot on yourself here, and that's admirable, but the fact of the matter is, before you even got involved in this case, this was happening, right?
I think that that's correct. Certainly, I appreciate Your Honor's trying to throw me a life raft here. Frankly, this case whirlwinded out of control. I wish I had done things differently early on. But yes, you understand the record correctly. It was a thing where they wanted more specific answers. They eventually got them. It did take longer than I wish it had standing here. But again, I think the material issue is, were we trying to keep anything from them? And I think the answer to that is
As you point out, it's a high level for the striking of a pleading.
Agreed.
And
yeah.
we fully understand that argument. We'll take a hard look at it.
All right.
Thank you, Counsel.
Thank you.
May it please the court, Jacqueline Thomas on behalf of plaintiff respondents. So, in this case, it's clear that courts favor resolution claims on the merits. That is true. But resolution on the merits depends on forthcoming discovery, right? And the courts have held that, and the CPLR provides that. And the courts have been clear that application of the sanctions set forth in CPLR 3126 are left to the sound discretion of the trial court because they're the court most familiar with the facts and the parties and what's been happening in the case. As the Court of Appeals has noted several times, the integrity of our judicial system is to be maintained. Litigants cannot ignore court orders with impunity.
Now, so we understand that in the law. Mr. Pretsch has asserted that all paper discovery was turned over prior to the motion to strike, the third one. Do you agree with that? Did they comply to this day? Do you have everything that you asked for paper discovery?
Wholeheartedly disagree
Okay,
with that
what is
assertion.
missing that you asked for that you didn't get?
Pardon me, Your Honor?
What did you request in order to produce on the paper discovery that you...
As of this point in time or at the time of the motion?
At the time of the motion. They say that everything was turned over, the medical records that had everything was March of 2019. But they say eventually all those policies, there were some of the 2016 policies got updated and so forth. They say you eventually got everything. By the time Judge Doyle struck the answer, you had everything you asked for. That's their position. You say that's not true?
When the motion was made, we did not have any of the policies and procedures because hospital didn't produce the policies and procedures that were in effect at the time.
They produced later versions of it?
Correct, the current 2023
Gotcha, okay.
versions.
All right.
Okay.
Did you get those 2016 policies?
Some of them, not all of them.
You still don't have all of them?
No, because they couldn't produce them. Because
'cause
when
they
you're
don't-
5 years later, it's a lot harder to find
All right.
policies from
Well-
2016.
All right. So you have everything that they claim that they can give you?
Everything that they claim that they can give us, yes.
Okay.
We-
And at the time that the motion was made, there were 11 witnesses that you wanted to depose. You
Correct.
had deposed 3 defense witnesses already, correct?
None of their witnesses, no, absolutely not. So very,
thought-
very importantly,
No defense witnesses have been deposed.
very importantly, all of the party witnesses in this case, with the exception of the hospital's witnesses, were concluded in the fall of 2019. The co-defendants, the plaintiff, the fall of 2019. And the hospital witnesses were scheduled in October and November of 2019, but for their failures.
Molly Frieda, Catherine Hackett, Veronica Ruiz, they were deposed?
Never.
Okay.
And Your Honor,
You agreed 4 didn't have any material information.
what we agreed to was we agreed to let them submit an affidavit that the witnesses said they had no recollection at this point, which is not too surprising since it was, since 2016 and we are in 2023.
Okay, well, this is what their brief says on page 20. It says, additionally, Molly Freedy, Kathleen Hackard, and Dr. Rees were all made available for deposition.
Absolutely false. Absolutely false.
So their brief is just misstating the facts.
Absolutely, and that's
Okay.
been part of the contentions
All
throughout
right.
this case. So, Your Honor, previously, you noted that...
Counsel, before we just move past that.
Sure.
Let me just see if I understand correctly. Made available, does that mean that they offered to try and schedule it, but that the scheduling didn't work? Or are you saying that they weren't deposed, therefore they weren't made available? Do you follow my difference?
Both.
Yeah.
So both. So
Yeah.
throughout this case, what would happen is we would ask the hospital, we would ask Mr. Presh. He says he was very late in the game on this case. He's handled every lick of discovery in this case, but yet he couldn't do these depositions. It had to be his partner, Amy Koch, who's never really done any of this discovery in this case. We would ask for Ms. Koch's availability. They would not respond to us at all. Then, as the judge became a little more irritated, and I can't even tell you how many conferences we had where the judge would say, you guys are going to hang up the phone and get these scheduled. Ms. Koch would give us 5 days to do 12 witnesses. And if you remember...
Well, isn't that, I mean, in fairness to the brief writing part of this, which is concerning to the court, you know, we want to make sure that the briefs are not representing facts improperly. Ms. Koch gave dates for the witnesses to be deposed, but they couldn't be agreed upon.
No. Let me finish the sentence.
Okay.
She would give us 5 days for 11 witnesses, and then we would say, okay, we're going to hold them. Let's get some of these done. Plaintiffs' counsel agrees to hold your dates. Let us know which witnesses you're going to produce. They would not respond. That was noted by the court. After giving us dates that we agreed to hold, we never heard back from them. Why? Because they couldn't find these witnesses. And I wanted to point out to Judge Lindley's point, there was not one witness that no longer worked for the hospital. There were 5, including the treating physician. They never told the court this. I agree Mr. Presh came in late in the game. He knew these witnesses no longer worked for the hospital, yet they continued to object. After 2 court orders directing them to respond to each and every demand, they continued to assert objections to such basic things as providing addresses for witnesses. Why hide the addresses of witnesses unless you're worried about what they have to say? And going back for a moment to the court's August order, where it really was fire and brimstone, and it told the hospital, I'm not going to tolerate this. I can't tell on the record before me if this is willful and contumacious, but I'm going to give plaintiff 2 depositions of every witness, if she wants, to flush out the issues about what were the hospital's policies, where did the CEWA assessment go, was this document destroyed? We don't know. And what did the hospital do? It hid the only witness who had any knowledge about whether or not the CEWA assessment was created, Holly Ronaldo Campbell. And it hid that she'd been terminated and failed to provide her address for 5 years nearly. Ms. Campbell, according to the emails submitted by the hospital in support of its motion to renew, was fired shortly after this action was commenced. Terminated. Did it have something to do with these events? We'll never know.
Can I ask you a question about prejudice? Not that that's a controlling factor here, but
sure.
You had make mention in your brief, and Judge Doyle did as well in his decision, that during the pendency of this action, the decedent's mother died. I guess it was her house he was going to, and adult son died.
Correct.
Do we know the dates of those deaths? There was a 2-year gap between when the decedent's lawyer filed the action.
Yes.
So it would seem to be material if we're going to hold it against the hospital for that you're missing witnesses when they died. Do you have dates on those?
They died in 2022. I know his son died very late 2022, I believe just before Christmas.
And the mother died earlier, 2022?
I believe so. I believe in the spring.
Okay.
Counsel, you should begin to wrap up.
Absolutely, Your Honor. Plaintiff's contention is that the hospital repeatedly ignored its discovery obligations, as well as numerous deadlines and directives by the court for more than 4.5 years, despite being given multiple extensions of those deadlines, until the court really had no other choice but to strike the answer. We believe the court's decision was sound and should be upheld.
Thank you, Counsel. Case 15, Inez Micro versus Tops Market. Mr. Nash?
Sorry about that, Your Honor.
Not a problem. Can you hear us?
I can, thank you very much.
And we can hear you very clearly. Mr. Zaccanino, can you hear us?
Yes, Your Honor.
Thank you very much. We can hear you. Please proceed, counsel.
Thank you, Your Honor. And may it please the court, it's going to be a relatively quick oral argument, I suspect. This is the case involving the lady who fell on the rotisserie chicken grease. We brought a summary judgment motion. I represent Tops. I think the trial court erred, at least insofar as the issues on did Tops actually create the grease. I don't think there's a real question that someone from Tops poured the grease on the floor and caused this condition. The deposition testimony in this case has come out to show that Tops denied knowledge of that actual pool or puddle of grease that was on the floor that supposedly injured the plaintiff. There was a manager in the vicinity who searched a couple of minutes before, and she said she didn't see anything. Which then leads us, as it does many times in premises liability cases, the issue of constructive notice. I'm going to focus my argument on this.
Well, before you do that, aren't they alleging creation by the fact that the containers for the hot chicken were insufficient to hold the grease and it therefore spilled? It was a common occurrence and so forth. Isn't that their creation argument? And why is that so outlandish?
I suspect it's more of the recurring condition. Well, we're going to address that fact pattern either on the not create or does not have constructive notice. And I'll say this. The plaintiff doesn't know how that grease got there. And yes, I fully recognize that at least one person, one Tops representative said, sometimes we'd have to put a second shell underneath the chicken to prevent grease from falling. But if you take a look at the PJIs, and I have them right here on the recurrent condition, the plaintiff has to show a specific issue, a specific recurrent issue. And that grease could have arrived on the floor any number of ways. It doesn't have to be the temperature of the grease and the plastic coating. It could be a faulty grease trap that leaked out. It could be a Tops store associate who just improperly stocked, that heating system that holds the chicken. It could be an elderly customer who couldn't hold it properly and it spilled out. I mean, there's a number of reasons of how that grease could have arrived on the floor, and it's just speculation on the plaintiff's part to assume that grease came from some issue with the shell, the undercarriage shell. And so for that reason, it's Tops' belief that the mere knowledge, the general awareness, and the PJIs seem to separate a general awareness from a knowledge of a specific issue. I don't deny that there's some general awareness that Tops had. But we haven't identified the actual cause of why this grease came to the floor, and for this to be argued is just pure speculation.
Right, but they don't have the burden. It's your motion for summary judgment. At trial, yes, plaintiff's going to have to have the burden, but here it's your burden, and you seem to be saying they can't prove it as speculation, but that's not what they're looking at on summary judgment.
It's my burden to show that it wasn't visible and readily apparent, and it had existed long enough that Tops could have rummied it. And on that issue, I would cite the fact that no one, be it the plaintiff or the Tops representatives who testified, saw it beforehand. And the fact that we have this Penny Domino, one of the Tops employees, who said, I was in that vicinity a couple of minutes before the fall. I didn't see anything. So from that testimony, we know that, or we can only conclude that grease was on the ground for a short period of time. I think the burden then goes to Lendon on the motion to make the recurrent condition argument in response to this.
Anything further, counsel?
No, that's it, Your Honors. I think you understand the argument. Thank you.
Thank you. Counsel?
Your Honor, may it please the court, Len Zaccanino representing the respondent plaintiff. Your Honors, this is, as you all well know, all we have to do is show these questions of fact here. We deposed 3 employees from Tops. This was something, and if you look at the record with respect to the testimony of Gabriel Marie Matina, she was one of the witnesses that we discussed, that we had taken a deposition of. She indicates, stated on many occasions, customers would request another bottom to the rotisserie chicken container or a bag because the bottom was leaking. This was caused in part because the hot grease from the chicken would melt the original bottom, and it goes on from there. The next paragraph says, customers requesting additional containers or bags was a common occurrence. Many times the containers were leaking, and at times the customer's request was preemptive because they knew the containers were prone to leak. It was also not uncommon for customers to pick up the chicken containers and leave the area, not mentioning to anyone that grease had spilled out of the container. So I just put forth to the court, there are questions of fact there. This is something that was created, and it's something that was recurrent over and over again.
Any further, counsel?
No, Your Honor.
Thank you, counsel.
Thank you, Your Honors.
Thank you.
Case 16 and 17, Warren versus Planning Board of the Town of West Seneca. Mr. Warren, can you hear us? We can't hear you. You've unmuted, but we still can't hear you. Can you try again?
How is this, Your Honor?
Oh, that's much better. Thank you. Mr. Warren, my understanding is you're appearing pro se in this case. Would you like to be heard?
Yes, Your Honor.
Proceed.
Good morning, Your Honors. My name is Daniel Warren, and I am the appellant pro se, and may it please the court. While my brief covers many procedural and evidentiary issues, I would like to highlight in my argument today some of the substantive issues raised in my briefs. My presentation on these issues will be slightly out of order than presented in my briefs. First, I'll address some of the issues that are typically raised in a challenge such as this before I address the recently enacted Green Amendment. This is my second challenge to this expansion of the Canisius Fields on Clinton Street in West Seneca, along the Buffalo Creek. In the first proceeding, Justice Iwick held that the prior actions of the Respondent Planning Board and town were without jurisdiction for failure to comply with General Municipal Law 239M, and that I had standing to challenge this project. No appeal was taken from that determination. I submit that Respondent's Planning Board in town lacked jurisdiction to grant the challenge determinations for failure to comply with General Municipal Law 239M again. General Municipal Law 239M requires that they provide to the Erie County Department of Planning all other materials required by the board in order to make its determination of significance pursuant to SECRA. The June 9th, 2022 SECRA determination of Respondent Planning Board specifically refers to 3 reports from the U.S. Army Corps of Engineers. I am the one that submitted these reports during the administrative hearings held by the Planning Board. I personally inspected the records of the Erie County Department of Environment and Planning for this project, and they are not in those files. Respondents have not come forward with non-conclusory evidence to establish that these reports were submitted to the Erie County Department of Environment and Planning. It should be noted that the trial court granted my request for a subpoena to obtain these records, but denied my request at oral argument for an opportunity to obtain compliance with it. Based on this, it is my position that the determination should be set aside for lack of jurisdiction. In regards to the SECRA portion of the determinations, the Planning Board stated in the minutes of the June 9th, 2022 meeting that all interested and involved agencies received the necessary information to review the project. However, neither the United States Army Corps of Engineers nor the New York State Department of Transportation in response to my Freedom of Information request and FOIL request contained any communication about this project from anyone on behalf of Respondents Planning Board in town. Deficiencies in the lead agency designation process warrant restarting the entire SECRA process. Further, the Respondent Planning Board stated in the minutes of the June 9th, 2022 meeting that the New York State Department of Transportation did not request one, referring to a traffic study, as on-site parking is not being modified as timing of the usage of the new field and the current playing field will not overlap. First, there is absolutely no document in the record from the New York State Department of Transportation stating this, and such was not produced in response to my FOIL request to the New York State Department of Transportation. Second, such document, excuse me there for a moment. Lastly, this logic is flawed in that an increase in traffic is not tied to parking lot size, but rather to the frequency of sports activities on the land. If this communication does exist, it apparently was not provided to Erie County as part of the General Municipal Law 239M referral as required as well. So there is no support in the record for this finding. Respondent Planning Board stated in the minutes of the June 9th, 2022 meeting that the town received a letter dated November 30th, 2021 of no significant impact referring to the United States Army Corps of Engineers. As can be seen from the record, this response from the United States Army Corps of Engineers dated November 30th, 2021 was not in response to, nor did it even address, any request on its environmental concerns related to this project. It was solely and merely a determination on its jurisdictional requirement for this project. So there is no record support for this finding that the U.S. Army Corps of Engineers had any issues with the environmental aspects of this project. The lead agency cannot merely set forth a conclusory statement unsupported by empirical or experimental data, scientific authorities, or any explanatory information. For this reason, the negative SECRA determination must be set aside. Respondent Planning Board also violated the open meetings law in the proposed negative SECRA declaration and in parts 2 and 3. Of the environmental assessment form were not posted on the Respondent Planning Board's website prior to the hearing, although prepared prior to the meeting. In fact, I had to submit a FOIL request and an administrative appeal to obtain these materials considered by Respondent Planning Board at this meeting. There is no reason that posting of this material prior to the meeting was not practicable. This deprived me and other members of the community of the opportunity to address this material and raise the points I spoke of earlier during the public hearing and prior to the Respondent Planning Board taking action. As a result, the adoption of the resolution was made in violation of the open meetings law, specifically Public Officers Law, Section 103E, and it should be annulled. If this court agrees with me that respondents' planning board and town's determination should be set aside based on either the procedural issues raised in my brief or the traditional substantive challenges, then it would be unnecessary for the court to reach my next point on the applicability and effect of the Green Amendment over this proceeding. However, if those issues do not rise to the level that requires invalidation of my challenge of the challenge determination, it is my position that the Green Amendment requires more than the current deferential standard applied to challenges based on SECRA. The Green Amendment became effective on January 1st, 2022. In April 2022, the prior determinations of respondents on this project were annulled. Respondents were required to begin the SECRA process anew. I raised the applicability of the Green Amendment to the Planning Board during the administrative process. The challenge determinations were made in June and July of 2022. I pleaded the applicability of the Green Amendment in the verified petition, and I raised the Green Amendment before the trial court. The courts have an independent duty to interpret and uphold the Constitution. This court has an independent duty and authority to afford the citizens of this state the full protections of their state constitution. When SECRA was first enacted, the courts were faced with the question of how it should be enforced because the legislature did not provide for judicial review of such determinations. The courts at that time determined that SECRA determinations should be reviewed like any other administrative determination with a very deferential standard. It is my position that with the enactment of the Green Amendment and the standard of judicial review of SECRA determinations need to be revisited, and a heightened standard greater than arbitrary, capricious, or affected by an error of law standard that is currently used should be heightened.
Mr. Warren, you should be mindful of your time, sir. I know you have 13 points in your brief, but you should begin to start thinking about wrapping up.
Yes, Your Honor. It may even include removing these types of challenges from special pleadings to plenary actions. The court should independently satisfy itself that the rights afforded by the Green Amendment are satisfied in any SECRA determination. I believe that this requires a heightened review of SECRA determinations. Currently, there are cases working their way up, and this court will be visiting as to whether or not the Green Amendment applies outside of a timely SECRA challenge. While I do not take a position on those, it clearly applies to a timely SECRA challenge. I submit that the determinations challenged in this action do not meet any standard and should be annulled. Thank you, Your Honors.
Thank you. Mr. Trapp?
Thank you, Your Honor. Good afternoon. I have to clarify a few things that were just stated. This is not the second time this matter has been here. In fact, back in 2009, Mr. Warren was involved in another case dealing with this very same Canisius project. At that time, there were the football fields and I believe maybe lacrosse. Council can verify any of that.
Mr. Trapp, just for clarification, you're representing the planning board from West Seneca?
I am now the town attorney. I became the town attorney in January 1 of 2022. There was a pending case in front of Judge Sywick at the time. That was argued, I believe, March or April of 2022. Judge Sywick remanded the case back to the town in order to follow procedure because at that time they did the seeker at the same time they were doing the planning board and couldn't do it. The reason it wasn't appealed was quite frankly when I came on board and it was remanded, it was just easier to do it the right way. Simple. So in this particular case, and what Mr. Warren hasn't said was, oh, yes, this case had originally been, the original request to do all the work was actually from 2021. And they had gone through multiple processes. When the Judge Sywick remanded it, we then went
sent everything out, and the affidavits are there. He says that there's nothing in the no evidence to submit that we actually submitted all the paperwork to the Army Corps of Engineers, Department of Transportation, SHPO for historical preservation issues, and the town engineering department. The affidavit clearly states that all of those were done. There are multiple papers. I mean, records are thick. The papers were submitted when we argued the case initially in front of the judge after he filed his second order to show cause in between return date of the first one and when we ultimately were heard by Judge Grisanti. I supplied to both petitioner and the court the documents that were submitted to the county of Erie. It was 4 inches thick. They had everything. There was no question. We've put that forth. The code enforcement officer indicated that all of that stuff was done. So at that point in time, the town had followed the proper procedure. You declare yourself lead agency, you do a seeker determination. That seeker determination was on June 9th of 2022. Petitioner was present. All of his papers and all of his letters were put into the record. Petitioner present, said nothing. When given an opportunity to speak at the public hearing, said nothing. After the planning board made the determination on seeker, we sent out everything, quite frankly, for the third time to the county Department of Environment and Planning. Said, review this once again, here are all the papers again. I made sure that they were sent from the code enforcement officer as he put forth in the record. More than 30 days elapsed, the county basically took the position, as did DOT and everyone else, not really our concern, it's a local matter, we leave it to you as the lead agency to handle. It was then, more than 30 days later, that the site plan was reviewed and addressed and ultimately passed by the town planning board. So the proper procedures were followed. You heard much of the argument was, well, I sent out foils to DOT, I sent out to Army Corps of Engineers, I can't help what they send him or don't send him. All I can do is send the documents to those agencies to review. If they choose, for whatever reason, not to respond, that is not on the responsibility of the town. The town's responsibility ends with making sure they have the materials, which was done in this particular case. With regard, I've addressed it in the brief. I'll just briefly touch upon the open meetings law. A quorum was present. It was held in public. Everything was timely. The notices were sent out. Mr. Warren was present, at least for the first one. He didn't show up to the second one. There really is no open meetings law issue. It is simply another thing to throw in there. With regard to the Green Amendment, you'll note in my brief I make reference to two cases. One, which is totally opposite, it's a landfill case out of Monroe County. We're talking about a baseball field, not even close to being similar. And the second case, which actually is relevant, came out of New York City, and they're talking about, we're not going to let plaintiffs just take multiple bites at the apple, which is exactly what Mr. Warren's trying to do here. He's trying to create something under the Green Amendment which should not be permitted, not when there's already been very thorough seeker reviews and reviews. This was not a one-time meeting with the planning board. This was over 16 months and multiple meetings. This thing was reviewed. The environmental issues were reviewed.
Anything further, counsel?
No, thank you.
Thank you. Mr. Cosgrove, you want to be heard?
Unless there are any questions for me, I have nothing more other than what I've said. And I agree wholeheartedly with Mr. Trapp.
Very good. No questions. Thank you, counsel.